Hi, I'm Stephanie and I'm Director of the Insolvency Company.
And I'm Gareth. I'm an insolvency practitioner at the Insolvency Company.
And we're also husband and wife. Gareth and I set up the Insolvency Company to be a friendly face in the world of insolvency, in the hope that if your business is facing a difficult financial future, you'd come to us at an early stage and potentially we could help you to avoid closure.
Today we're going to cover some FAQs and talk a bit more about the world of insolvency.
If I speak to an insolvency practitioner, or they speak to an insolvency practitioner, will they get into trouble? I think there's a sort of insolvency practitioners, you see these, don't speak to an insolvency practitioner, so we'll go into that in a minute, but is there a chance they'll get into trouble? How do you see that?
So, no, you won't get into trouble. First of all, as an insolvency practitioner, I always start my calls by saying, look, everything you discussed with me today is confidential. I'm here to help, I'm here to advise. You don't have to follow my advice, but at the very least, you'll leave the conversation or the meeting better informed and you'll have an idea of your options. You don't get into trouble. If anything, it's a positive because you'll receive some communication from me to show that you were proactive and you took advice at an early stage to assess, you're fulfilling your duties as a director. Every director has we call it a fiduciary duty. What that means is to act in the interests of the company. Okay. So you're supposed to promote your company and act in its best interests. And taking advice is acting in its interests.
Is there a cost for that advice?
No, the initial conversation with me is always free. And a lot of the people we speak to after that conversation actually don't need our services, and we'll tell them, we'll say, no, you're doing things the right way. You can think about, getting some more services from your accountant or looking at finance or restructuring, various options. So, yeah.
They can have that call with you for free, which is brilliant. So they get that initial advice. And then what happens? Do you send them anything? Do you give them any more information? Where does it go from there?
So we email them. We summarise what the conversation was. It's obviously you want people listening to you during the call rather than taking loads of notes. So we summarise that. We send an email, and that covers our advice. And then it's up to the client then what they want to do. Usually there'll be some follow-up actions, some recommendations, and if they take those and they have further questions, they can just get in touch.
Right, so they can have a free call, get the advice, and then the summary, like you say, with the advice, and then they've ticked that box. So in terms of if there's a business struggling, it's a case of actually pick up the phone, get that advice, because it might mean that you don't then need an insolvency practitioner.
Yeah, okay. and especially when a business is struggling, there are certain things that you should and shouldn't do. So being aware of those things is very useful.
I've seen adverts that say, don't speak to an insolvency practitioner. Why do you think people say that, and what would your advice be?
I think that the companies that tend to recommend that are offering a solution which isn't necessarily in your interests as a director. So it might work, but if it doesn't work, you could end up in trouble. Yeah. So it usually involves kind of shutting the company down, avoiding the debts, doing something that's not necessarily ethical or correct.
And I think, because one of the things is that the insolvency company, we're regulated, aren't we? So
we're regulated and insured, so that if we make any mistakes and you sue us, our insurers will pay.
So basically, you're getting advice that is insured. So rather than just speaking to somebody down at the pub, as the old saying goes.
It's the protection of that advice. You know that you're getting advice from someone who is regulated, audited and qualified. And we undergo regular, quite intensive inspections. So that shows that to be able to keep that license, you have to do that. You have to undertake continuing development. You have to stay up to date on the law. So we know what is happening and what changes have happened. We're up to date. Whereas if you're seeking advice from somebody who is unregulated, there's no guarantee as to the quality.
Yeah, I think we were saying, weren't we, that actually it's really important to speak to an expert in their field. And because you can speak to an insolvency practitioner without you don't have to sign up, you don't even have to pay usually just for that initial advice. There's really no barrier other than what you might have heard. But the truth is, go get that advice, so that in the hope that you won't then need their services moving forward. Okay, thank you. So if I'm a director, so I'm running the business, and I come to you and decide to liquidate the company, is there any redundancy? Is there anything for me, like what are the benefits of me going through that process?
As a director?
Yeah, as a director.
So in terms of qualifying for redundancy, it very much depends on whether you are classed also as an employee. So a director is an office holder, right, and an office holder is not an employee. It's somebody who is managing and responsible for the company. So you might get office holders remuneration, you might get paid like a salary, but that doesn't mean you're an employee. To be an employee, you've got to have things like a contract of employment, you've got to be paid at least the minimum wage, and that's the key one. Most directors receive a tax efficient salary because the accountants say this is the best way to minimise tax. People paid a tax efficient salary will not class as an employee and they will not get redundancy.
Do you know, just yesterday I saw some accountants recommending the best sort of tax efficient salaries, and I was thinking that's all well and good except for the businesses that do need to close. And I think we were saying, like, statistically, something like 3 out of 5 businesses will close within their first 5 years, or different places give different statistics. But the point is, nobody really wants to talk about closure, but actually I think understanding and protecting yourself. So, like you say, making sure that as a director you're being paid more than minimum wage, so that if things don't work out, that redundancy pay could be your lifeline to start your next business venture. And so, but people don't, because nobody wants to talk about it. The other day, someone was asking about, there was a podcast and they were talking about, things businesses wanted to know, how to like connect on LinkedIn and things like this. And when I put ours forward, they're like, oh no, we don't want to talk about that. And it's like, well, actually protecting them, making sure they're aware of the very worst case scenario and how to get through that the best way at the beginning and hopefully never need it. Surely that's better than getting there ill-informed and then, like you say, not being able to get a redundancy.
It's setting things up the right way. It's like you take out insurance, you hope you'll never need it, but you still take it out because it protects you in the worst case. Yeah. And things like making sure you paid minimum wage, making sure you've got a contract of employment, because most directors anyway, will give their employees contracts but not themselves. Make sure you've got that contract of employment. You track your holidays. Actually take some holidays as well if you can. That would help. And the more of those that you tick, the easier it is to claim redundancy when it comes to that situation. Yeah,
I'm laughing to myself here because I know, like, when you're running a business, like some of these things, like you say, like the insurances or things, and you think that you'll never need, and it's sort of human nature. You don't want to look at it. And I'm not, we work in insolvency and we know it's not the most exciting part of running a business. And it is really important, and just making sure that, like you say, you do things the right way to protect yourself, because at the end of the day, things like your own home could be at risk. People probably got families that they're trying to pay for, and so this is like the worst case scenario, and we're thinking, well, how can we best help people get through that? One of the biggest things that we see is personal guarantees. I just wondered if you would explain, so what is a personal guarantee? And
so if you're a business, for example, and you want to borrow money from the bank may require a personal guarantee, a promise from a third party to repay that if the company can't. Yeah. So usually the director will promise to pay the bank back if the company fails.
Because the company and the individual are separate legal entities, so yes. It's not so the business might not work out, but don't worry, I'll back it up. I've got a house, so I'll do a personal guarantee. Yeah.
And it's really common in business because it's very easy to close a business and kind of leave that debt behind. So the banks and suppliers and other parties want that security that they're not just giving you money and it's going to be lost. So they'll ask you to sign a personal guarantee. And they can be useful because they give businesses access to credit that they otherwise wouldn't get. So when a business is trying to grow, or they've got customers that pay them on lengthy payment terms, 90-day payment terms, they might need that credit to be able to keep the business going. Yeah. It only becomes a problem if a business is struggling, because if a business cannot pay that money back, then the bank or the supplier is going to ask the guarantor, the director, to pay it back personally.
So is that something you see quite a lot?
All the time, unfortunately. And the worst times to take out a loan with a personal guarantee are when a business is already struggling. Because when a business is doing well and you're just using it for extra cash flow for credit, and it's to grow the business, that's fine. But when you take out a personal guarantee when a business is already struggling, that's a sign that the business can't afford to kind of keep up its liabilities.
So
and you're adding an extra level of credit in there, an extra cost that you're going to have to pay, and it exasperates the situation.
So there's a much higher risk of the business not being able to repay it, so it's going to fall on you personally. And actually, we see that, like you said, often, that at the point, the director, we would have advised them to come and have a chat with us, is the point that they've gone to their bank and got a loan with a personal guarantee. And suddenly, things like their house becomes, is brought into the picture, whereas previously the business being a limited company was a separate entity and therefore they were separate. And that actually, it makes us feel sad because we think if only they'd come to speak to us. Not to say that we wouldn't have said go to the bank and get the loan, but we would have liked them to have known the implications at that stage.
Yeah.
If you have any questions, if your business is in difficulties, or you'd just like to know a bit more about insolvency, send your questions to the Insolvency Co.